Do you want to know how exactly?
Rules Committee will come to order. Thank you very much, and want to welcome everybody back to the day when we will welcome the President of the United States to the United States House of Representatives. And as a result of that, we are trying to meet earlier than what we normally do. We still have important business that must be begun today. And so we have some members who are here and some who are not here as a result of the earlier schedule that competes against them being home and still getting here properly. So the committee will consider H.R. 161, the Natural Gas Pipeline Permitting Reform Act, and H.R. 36, the Pain Capable Unborn Child Protection Act. H.R. 161 streamlines our permitting process to provide what I believe much-needed natural gas to many more areas of the Northeast and the Midwest, where the demand for clean energy is high, but pipeline infrastructure is insufficient. Due to the abundance of natural gas and the affordable price and it being a clean natural gas, many manufacturers are beginning to rely on natural gas as a primary fuel. Providing these businesses and homes with cheaper energy will promote domestic manufacturing, jobs, and will keep good-paying American jobs here in America as opposed to going overseas because of price considerations. H.R. 36 would prohibit abortions with limited exceptions after the point at which scientific evidence shows that an unborn child can feel pain. We owe every child the opportunity to a long and full life. This legislation reaffirms that commitment. I want to thank today not only Mike Pompeo, the gentleman from Kansas, for being here today from the Energy and Commerce Committee, and Chairman Goodlatte, but also our guest who will be with us today, Paul Tonko, representing the Energy and Commerce Committee, and Steve Cohen, who will be here on behalf of the Judiciary Committee. I would like to have both of you please come to the table. As each of you know, the Rules Committee is delighted that you're here. If you don't believe that, I'll tell you right now, we're delighted both of you are here. Your testimony of important legislation is important that this committee not only hear from you. Mr. Tonko, I don't need to remind you, you're a Democrat, and you represent your party, but you also represent the Energy and Commerce Committee. We have Democrats here and Republicans who are on this committee, and we try and work well together. And we look forward to your testimony. Without objection, anything you have in writing will be entered to the record. And before we start with you, Mr. Pompeo, I'm going to defer to my dear friend from Worcester, Massachusetts, the gentleman, Mr. Montgomery. He'll correct me. That's a Texan for.
It's Worcester, but
Worcester.
we'll work on it. We'll work on it. But today, je suis Louise, so I'm going to open up with a brief statement.
Recognized.
Mr. Chairman, we're all happy to hear that our colleagues on the other side of the aisle intended to make this Congress into a place where we can work together. But I must say that the results so far have not been good. Just let me give you a few statistics. 5 closed rules after today, 100% waivers of the rules just for Republicans, 100% of our Rules Committee meetings have been emergency until today, and 100% of the bills the Rules Committee has sent to the floor have drawn a veto threat. You continue to close down the process, rush bills through the House without regular order, enforce the rules for Democrats but not for Republicans, and insist on spending all of our time on partisan legislation that you know will never be signed into law instead of talking to the other side. And I just, before I close, would just ask unanimous consent to insert in the record statement of administration policy both on H.R. 161 and H.R. 36, which both say that if the President is presented with these bills, he will veto it. So
that objection, they'll be entered to the record.
I hope that after today we can get back to a more regular process where there is input from the minority and not just direction from the majority. So with that, I yield back my time.
Gentleman yields back his time, and I appreciate the gentleman not only for his comments, but also for his insistence that this committee continue to try and strive for an opportunity for us to reach a consensus about jobs bills that would be good and tax bills that would encourage more investment in the United States. And I promise we're going to bring those bills. It may not be bipartisan when it comes up here, but it darn sure turns that way one way or another on the floor. And I appreciate the gentleman's comments, and thank you very much. Mr. Pompeo, welcome. I hope Susan's watching today because you're one of our lead witnesses, not only today, but of this new session, and she is darn proud of you and has reason to be, and we're delighted that you're here.
Thank you. Thank you very much, Mr. Chairman. Thanks for the opportunity to talk about H.R. 161, the Natural Gas Pipeline Permitting Reform Act. It's common sense. The good news, this is a bipartisan bill as well. I'll talk about the history of this legislation. This is not the first time I'd introduced it. And we'll talk about how Democrats and Republicans alike understood that this made good sense in the last Congress. We've got domestic natural gas production, as you said, at all-time highs here in America. We now have to get that energy from the places it's produced to the places it's consumed. Primarily, this is the Northeast, a place where you have lots of folks from both parties, and places where we have enormously high natural gas costs that are making it very expensive for the least amongst us to do the simple task of heating their home in the wintertime. And we can fix that. We can fix that by streamlining a permitting process that today allows folks who want to invest tens and sometimes hundreds of $millions in new pipeline infrastructure to get hung up by the federal government that simply refuses to make a decision. It's worth noting that this piece of legislation in no way makes any change to any underlying environmental statute, not to the EPA rules, not to the Clean Air Act, not to the Clean Water Act, not to NEPA, no changes at all. This bill, if enacted into law, would do the simple thing of telling the federal government, hey, you have to make a decision. Eventually, you have to tell these private entities that are trying to provide affordable natural gas to people all across America, either yes or no. The answer can be no. The answer can be yes, but you can't just sit on their application. Gives them 12 months to do that. We got lots of feedback from FERC as we were working through this process. What's possible? What can you accomplish? How can the 9 agencies that have a role in the permitting process work together to get to a good outcome? And we made some substantial changes. We made it only apply to certain applications that have been pre-filed, so it limited the universe. We were working alongside our Democrat colleagues all throughout the 113th Congress. And we introduced it. It was H.R. 1900 in the 113th Congress. It was introduced in May. We had an extensive hearing in the Energy and Commerce Committee. We heard from NextEra Energy. We heard from FERC itself. We heard from the Delaware Riverkeeper Network, from the Pipeline Safety Trust, from the Distribution Contractors Association, and from INGA, all talking about how this would help impact the ability to get pipelines permitted through the normal process. It passed through the committee 26-14, and then ultimately came to the floor and passed with 250-plus votes, including a substantial number of Democrats who thought this was good legislation that would make sense for America and for affordable energy. I look forward to answering your questions, but what we've got here is a piece of legislation that tries to get at this challenge of making sure that this new abundant energy source that we can now get out of the ground affordably can get to those who need it most. And with that, I yield back.
Mr. Pompeo, thank you very much. Very succinct and straightforward conversation with this committee. I appreciate it. Welcome.
Thank you.
We're delighted you're here. The gentleman is now recognized.
Thank you, Chair. I thank you, Chair Sessions, and Ranking Member Slaughter, and all of the members of the committee for allowing me to appear before the committee to discuss H.R. 161, the Natural Gas Permitting Reform Act. This legislation, which passed the House last Congress, is deeply problematic. Although perhaps well-intentioned, it would disrupt a functioning permitting process, and it would put the Federal Energy Regulatory Commission in charge of making permitting decisions within the jurisdiction of other federal agencies. The best way to describe this legislation is that it is a solution in search of a problem. But the real problems would begin if this legislation were to become law. This is a new Congress, and this is precisely the type of legislation that should be examined in the Committee on Energy and Commerce and brought to the House under regular order with an opportunity for members to offer amendments on the floor. Instead, we're bringing it to the floor without hearings or markup and considering it under a closed rule. If we did conduct hearings, we would find out once again that this bill would make permitting for pipelines slower and more complicated. That is why the last time this legislation was considered, the President indicated that he would veto it, and we heard earlier from Representative McGovern that that would be the case in this instance situation. I have no reason to believe that his position has changed. We're told that H.R. 161 seeks to speed up the approval of interstate natural gas pipelines. But the nonpartisan Government Accountability Office has concluded that FERC's pipeline permitting process is predictable and consistent and gets pipelines built. In the past Congress, the pipeline companies testified that the process, and I quote, is generally very good, and that the sector enjoys a favorable legal and regulatory framework for the approval of new infrastructure. In short, this is one government program that works and works well. H.R. 161 would disrupt this functioning permitting process by arbitrarily limiting the time that FERC and other agencies have to review pipeline applications. These time limits will have one of two possible outcomes. One outcome is that agencies conduct inadequate environmental reviews and rush to approve permits that do not comply with our nation's health, our nation's safety, and our nation's environmental laws. Alternatively, the agencies can deny permits when the time limits prevent them from completing legally mandated pipeline reviews. This would be a bad result as well, because needed pipeline capacity would either not be constructed or the applicant would have to begin the permitting process over again. But that is not the end of the problem with the bill. H.R. 161 imposes a one-size-fits-all time limit on all pipeline permit applications, no matter how complex that project request might be. Permits that require longer time periods are those that are of greater length, perhaps, or cross densely populated areas, private lands, agricultural areas, sensitive or unique environmental resources, and areas under other economic uses. Additional time is required to enable FERC, other federal agencies, and the pipeline permit applicant to work with the affected individuals and the affected communities. Short-circuiting this process is likely to garner more public opposition and possibly higher court situations and fees. This bill may or may not speed up pipeline permitting, but it will have adverse safety, health, and environmental impacts. This legislation should be reconsidered by the Energy and Commerce Committee. Since the committee will not consider H.R. 161 prior to its consideration by the House, we respectfully request that you grant an open rule to allow all members an opportunity to offer amendments to this important legislation. And I then thank you for your consideration and attention to H.R. 161.
Mr. Tarco, thank you very much, and for your succinct discussion with this committee about your ideas related to this bill. We have seen this bill. We have understood this before, and we're delighted that both of you are here. And I would yield to the gentlewoman from North Carolina.
Thank you, Mr. Chairman. I, too, appreciate the succinct presentations made by our colleagues. I think sometimes you need to say a little stronger your comments that prepared statements will be placed in the record, but thank you guys for being succinct. Because this bill is almost identical to what we've had before, I don't think that we are violating principles here by moving this bill early in the session. I think it's the right thing to do. It's the right thing to do to say that we should not burden business, industry, and the American people by the inaction of bureaucrats who simply don't want to make decisions sometimes. And so I'm full support of the bill, and I yield back my time.
Thank you very much. The gentlewoman, as you see, probably triples her duty. One, she's a vice chairman of the committee. Secondly, she's a colleague, and occasionally she loves to give me wifely advice. And I'll let you figure that out, Mike and Paul, but I accept that, and thank you very much, Virginia. Gentlewoman yields back her time. Gentleman, Massachusetts recognized.
Thank you, Mr. Chairman.
He didn't say
Well, I think there's bipartisan agreement on one thing. We appreciate your succinctness. But that's probably where the agreement ends. Putting aside the regular order issue, which is that notwithstanding the fact that there are a lot of new members of this Congress, there hasn't been a hearing or a markup in the 114th Congress on this bill, and I granted we've been through this last session, but I don't, this is a new session, and I think everybody deserves at least an opportunity to weigh in, and if not in committee, then certainly with an open rule. I also, Mr. Tonko points out that this is a bill in search of a problem. I mean, my understanding is that FERC decides 90% of certificate applications within 12 months. I don't think that that's an unreasonable amount of time, given the complexity of some of these pipeline proposals, and that and from what I've been able to read, the regulatory agencies and the industry seem to be okay with the current process. Maybe there are some energy companies that would prefer an expedited process with arbitrary deadlines. But I just want to say one thing. I come from the Northeast. And right now, we are dealing with a proposed pipeline that goes through Massachusetts. What bothers me about the way this is unfolding, and again, and this is before your bill, is that I think the current process, as it is laid out, turns us back on a lot of legitimate concerns that communities and states and businesses have. We have a pipeline that we're told that it doesn't matter what the state thinks, doesn't matter what business thinks, it doesn't matter what local governments think. FERC will make a decision, and that's where it goes. And just to kind of give you an example of some of the frustration that some of the people in Massachusetts are having, is that the proposed pipeline that's now before FERC would actually go through a lot of farmland. It goes through a farm in Deerfield, Massachusetts, an orchard, been in the family for 100 years old. But the requirements of, I guess, a 100-foot easement to put this pipeline in would require this farm to literally rip out of the ground hundreds of their trees, basically making their farm not profitable anymore. And what they're told is, hey, for the greater good, those are the breaks. The inability of communities to be able to work better with the federal regulatory agencies, and FERC in particular, or the federal government, to be able to find alternative routes, that don't disrupt farmland, that don't go through conservation land, I think is very frustrating to a lot of communities. And so the idea that we're going to even rush it even more, and bypass, there's an amendment that Congresswoman Tsongas, and I'm going to propose along with her, that would simply keep, that would be an amendment to your bill, that would simply keep existing review process in place for proposed pipelines that cross federal, state, or local conservation or recreation land. In Massachusetts, one of the proposed pipeline we're talking about cuts through a number of protected lands, Northfield State Park, Montague Aquifer and management area. And I guess the argument is if we've already invested federal and state money into identifying these lands as environmentally sensitive, it makes no sense to expedite the approval of a pipeline that could bulldoze right through them. And so while I appreciate some energy companies wanting to kind of brush things through, here's an example where I think by rushing things through, we may be undercutting, things that have already required significant federal investment. So I hope that the gentleman would be at least open to allowing there to be discussion on that amendment and maybe some other amendments, because I think there are some legitimate concerns that a lot of local communities have. I understand the need for energy, and again, my people want lower energy costs too, but it's not only one way to get it. And I worry that what we're doing here is, we're taking more say away from a lot of the local communities into how the energy gets into their states, rather than doing anything that's in the interest of the common good. So I hope the gentleman will be open to a little bit of an open process where some other ideas might be able to be talked about on the floor. I yield back.
Gentleman yields back his time. The gentleman from Oklahoma, Chairman Cole.
Thank you very much, Mr. Chairman. I won't take long. I just want to thank my friend from Kansas for bringing the legislation to the floor. It's a problem we're fairly familiar with in our part of the world. I do have one quick question for you. Could you just elaborate for a moment on the cost that delayed decision-making have for not just the pipeline companies, but for the exploration companies, for the royalty owners? There are a lot of costs that are associated when there are unreasonable delays, and a lot of market volatility, as we know, that may change the whole calculation for the pipeline.
So I appreciate the question. So the costs are really two primary buckets. The first is the one you referred to at the end, which is when a company has often been asked to build a particular pipeline, that as a community comes and says, hey, we've got a gap, we're paying double, triple what normal rates for natural gas would be. Can you deliver us product through an additional increased set of pipelines or capacity or some additional capacity expansion? Those things change. And so you have to, if you're going to commit $150 or $850 million to build that pipeline, you have to know that you have some reasonable certainty that if you set aside that capital, you're going to at least get an answer. You're going to go do the engineering. You're going to go do all the work that leads up to even the permitting application process. I didn't talk about it, but there's a multiple-month process where all of the stakeholders are brought in even before an application is filed. It usually takes 6 or 8 or 10 months where stakeholders have an opportunity to comment even before the application is filed. You need to know that you're not going to be strung out for 3 or 5 or 7 years, that you're going to get to make your case, you're going to get to hear from the stakeholders, and then you're going to get a decision. And you may not get the decision that you thought, but you won't have to set aside capital and put all of these processes on hold for where you're going to deliver that natural gas for years and years and years. We're just simply asking that there be an endpoint for the decision. It doesn't change NEPA's capacity to say, no, we think this is environmentally sensitive and not an appropriate route for a pipeline. It doesn't give stakeholders any less opportunity to speak or comment. It simply says that once that work has been done, FERC or none of the other agencies should be able to sit on their permitting decision, often in an effort simply to make the project go away.
And isn't it true that quite often FERC and the other permitting agencies have been involved in the lead up to the year? So it's not as if we're just talking about a year here. They have been intimately involved in discussions. They should be knowledgeable and familiar. Somebody didn't just show up and say, here's an application. You've never seen anything about this before. You don't know anything about it. And a year would still give you an awful lot of time to make the decision. But I would suggest that it's worth pointing out that this decision-making process is a lot longer than a year.
For a pipeline of any complexity, the process pre-filing, before the application is even submitted, often runs 8 months, 10 months, a year itself. So you're talking about from start to finish, often a couple of years.
So, again, I just want to end with a point that this is simply trying to get the federal government to do its job in a timely fashion. It's not dictating the outcome. It's not waiving any environmental rules. It's just saying, having been involved in the pre-application process, you ought to be able to make a decision within a year. It's pretty hard to argue that that's not a reasonable length of time for a regulatory entity to come to a decision. So I thank my friend for bringing this to the floor. And with that, Mr. Chairman, I yield back.
Gentleman yields back his time. Thank you very much. Gentleman from Colorado is recognized.
Yeah, Mr. Tonko, so this applies to pipelines within our country also. Does it apply to pipelines that might be built to ports for exporting natural gas?
I believe that it would,
So it seems like, I mean, there's an argument that this somehow could reduce natural gas costs, but one could also make an argument that if in fact it's transporting natural gas to ports for export, it could actually increase natural gas costs here if more of these pipelines are built. Is that correct?
absolutely.
So I'd be happy to yield to the
Yeah,
gentleman.
no, that's an interesting point, because I met with the energy company that's proposing the pipeline through Massachusetts and asked specifically how much they would anticipate an energy cost lowering in our state as a result of the pipeline. And the answer is they can't guarantee anything. When I asked how much of it would be, exported out of the country, we get into discussion of market forces and wherever the demand is. And so, we have a situation in Massachusetts where they have a proposed pipeline that could go through conservation land, to people's farms, to people's businesses, and no guarantee that at the end of the day you're going to see a decrease in prices. So, from a community perspective, there's a lot of unease about this whole process as it exists. Never mind what's being proposed today. I thank the gentleman.
And the gentleman from Kansas, if the Pipeline Association is happy with the current process, who is unhappy with this process? Who's seeking this bill if the people who actually build the pipelines don't even want this bill?
Well, it's my bill.
It's
my bill, so I think
obviously
it makes
you
good sense. But we've heard from lots of folks. Consumers are the folks that are the primary.
Wait, are they real clear, American consumers or consumers in other parts of the world?
No, sir. American consumers who are paying outrageous price. You've got $30 an MCF at the wellhead at the Boston gates. That's outrageous. It's unnecessary. And this is not asking to build pipelines where it's unsafe, where there's an environmental risk. This just says, do your job. It just says to the federal government, do your job. Give an answer to those consumers who are demanding that their energy costs be at a market rate. It's that simple. It doesn't impact any communities. It just says, do your job.
Yield back the balance of my time.
Thank you, Mr. Chairman. Mr. Tonko, you made a compelling point. You said, golly, there are only two things that can happen if you start setting these kinds of deadlines. Either folks will have had to have completed their work before that deadline comes and then approve the application, or they won't have been able to approve the application in that time period, and so they're just going to have to reject the application because they couldn't get their work done. Is there a time frame out there that we can agree? Because my understanding from what Mr. Pompeo has presented is that we're not talking about a floor where we're saying you can only use a week or you can only use 10 days. We're talking about a ceiling that you shouldn't ever have to go longer than this. If the ceiling that Mr. Pompeo is proposing isn't the right ceiling to prevent the arbitrary rejection of pipeline applications, is there a ceiling that you all discussed, Energy and Commerce, during the hearings last year that would be the appropriate ceiling?
I think the important thing is that when you talk about having the professionals do their job and get it done, that's what I think we authorize here. We're asking that they be given the professional courtesy to do the job and do it well without short-circuiting the process. As we know, a great majority, a supermajority of the applications are approved in a relatively sound time frame. Some of them are more complex. Listening to the arguments about fiscal impact, there's a fiscal impact beyond the applicant or those we've already discussed. There's an impact that comes via public safety, public health, jobs in the economy, environment, to the host and donor areas. So, both sides have potential economic consequences here. All we're saying is do your job, which you're asking for, but do it thoroughly. We're trying to intercept here when we shouldn't. We have given standards that need to be met. We set those standards. We're not the technicians. We set the goals. We set the policies. We should let the professionals do their thing, give them the courtesy, the professional courtesy, to utilize the time requirement that is reasonable for them to get that work done. I, before coming here, represented a New York State Assembly seat. And within that district, tragically, were the location of pipeline explosions that caused deaths and destruction. And so I want to know that professional people will be given the courtesy to do their job thoroughly and not some artificial constraint that comes onto the process that said, hey, do it within this time frame.
Mr. Pompeo, I think there's some wisdom there. I often wonder why Congress gets into all the things it does get involved in, because we're not the experts, we're not the technicians. Though my understanding is that the experts, the technicians, the guys at FERC today already have guidelines in place, but those guidelines have no teeth. They say you ought to, we're going to send this application out to you, you ought to take a look at it in 90 days, but if you don't, well, then take 120 days. And if that doesn't work, then take 180 days. There are guidelines in place, but without teeth, no one's paying attention to them. What are the technicians saying about an appropriate timeline?
That's right. Thanks for the question. So there are guidelines, and oftentimes they do complete their permitting process in a time frame that's reasonable, but many times they're not getting that done. I'm much less worried about professional courtesy to a bunch of government employees than I am to providing courtesy to the consumers who really need this energy at an affordable price. I guess from my perspective, if we're gonna get it right, we should worry less about their peculiarities and just tell them to complete their task in a reasonable time period. You should know, you asked the question, what would be a reasonable time if 12 months isn't enough? What would be reasonable? We asked the same question, and as you heard again today, there's no answer to that question, whether it's 13 months or 17 months or 7 years. I've not yet been told what date certain would be a reasonable date to ask a bunch of federal employees just to complete what's a pretty straightforward process.
Well, I don't dispute that these are complicated permitting applications. I don't dispute there are folks on both sides of the issue, even when it's a simple permitting application. But it is not lost on me that for folks who are concerned about hometown impact, for folks who are concerned about exports, those folks are not on the side of let's set a deadline so that we'll just have to reject all of these applications. They're on the other side that says let's not set a deadline that's going to force folks to complete these applications. I think if we were really going to end up rejecting applications because they were unfit, the votes might break down differently on this bill. I think what you've hit upon is folks really can do better. We as federal employees really can do better. If you can't measure it, you don't perform to it. And what you are offering here is an opportunity for us to measure federal employees' performance, and if not, we'll be able to identify where that burden lies. So I'm grateful to you for pushing this forward. Mr. Chairman, I will close with this. I agree with Mr. McGovern when he talks about regular order, when he talks about a process. I think everything he said is absolutely true. This early in a session, you've got two choices. You can either burn through a lot of time and a lot of daylight trying to rehash the exact same material you just did last December, November, October, September, or you can take those bills that have already been worked on the hardest and the best and try to move those bills forward first. I sit on committees that haven't even organized yet, and I think the American people deserve better than us sitting around doing nothing while that tries to happen. I know of no more territorial group on Capitol Hill than committee chairman. And with all due respect to my current committee chairman, of course.
Thank you, gentlemen.
But it is not lost on me that the chairman of the Energy and Commerce Committee says this is a bill that has been thoroughly explored, that we've had numerous hearings on, that we have done line by line by line by line, and that this is a bill that he doesn't have any objection coming to the House floor in this way, and that gives me great comfort. With that, I yield back.
Gentleman yields back his time. Gentleman showed great wisdom in his remarks, and I stand with the gentleman for what he said. Gentleman from Ohio, Mr. Stivers, is recognized.
Thank you, Mr. Chairman. I appreciate the gentleman from New York and the gentleman from Kansas for being here. Appreciate both of your opinions on this. I can tell you that my constituents in Ohio and all our hardworking taxpayers across this country have seen the value of cheap gas at the pump the last few months. And, you know, when I drove by the gas station this morning and gas in Ohio was $1.89 a gallon, my constituents like that. It means for hardworking taxpayers, it means more money in their pockets. We need to look at every policy decision we make and say, how can we sustain and expand this to the best of our ability? And so I have a few points I want to bring up. I did appreciate the gentleman from Georgia's comments about what happens early in a Congress. And, you know, I think the American people expect us to do some things. And when a bill got 257 votes, maybe I'm wrong, but I think it got 257 votes in the last Congress, a bipartisan majority, a pretty big, overwhelming bipartisan majority. That's the kind of bill I think we can start with. It is unfortunate that there's a statement of administration policy that says that the president would veto this bill. I do want to ask the gentleman from Kansas, because I just read the statement of administration policy and I'm having a little trouble with it. The first paragraph says the timeframes are rigid and unworkable, and the third paragraph says that 91% of applications are actually approved during these timeframes. And I just am having a little trouble with how they are either rigid and unworkable, and they still, on a federal government curve, that would be an A, a 91%. I guess but it seems to me like if you don't measure what's going on, you'll never know. And the great thing about this bill is it forces them to make a decision, doesn't exempt anything, it just forces them to make a decision. Do you think if they're doing it 91% of the time, that seems rigid and unworkable to you?
I don't. When you really look at what's going on inside, not just FERC, but there are multiple agencies that review most all of the natural gas pipeline permits. There's a handful that don't go to every agency, but most all of them go to each of those agencies. What you'll see is many of them are small, uncontroversial. They're moving down an existing right-of-way. They look and feel more like a repair than a new pipeline, but a permit's required. All of those are in that 90%. The real challenges are in those places that are underserved, right? The place that you're getting this hang-up, the delay that is causing increased natural gas prices for consumers are in these places where you're really making a significant leap forward in the ability to serve real consumers affordable energy. And so the 91% is true, but in some sense it doesn't represent the real opportunity that there is to get this natural gas to the right places today.
Thank you. And the gentleman from New York brought up a point about, you know, a pipeline explosion. What's the alternative, Mr. Pompeo, to transporting this oil if there aren't pipelines built? Would it be rail transportation? And if so, isn't that even more likely to have a problem than a pipeline?
So natural gas is even trickier than crude oil in terms of transportation, and pipeline is far and away the safest way to transport this product from its source in the ground to consumers at the endpoint of the transportation supply chain.
Great, and I just have one last point. So the gentleman from Colorado talked about export terminals, and just because a pipeline is approved to go to an export terminal, don't export terminals have to be separately approved by the Department of Energy?
Yes.
So
Absolutely.
there's a separate approval, so it's kind of a red herring.
There's
There's a whole separate approval process.
There's an entirely separate approval process. This doesn't impact that at all. The existing set of rules would continue to apply even after this became law.
Thank you.
Excuse me, the existing set of rules with respect to natural gas exports would continue to apply.
Thank you. It seems to me that if we're able to do it most of the time, we just need to get a little better. If this is the safest alternative, we should be pursuing the safest alternative. And obviously, there are other issues like export that can come up, but there's separate approval. This is outside of that. This is about approving the safest possible transportation for this product to ensure that the hardworking taxpayers I talked about at the beginning of my remarks can continue to see abundant, affordable energy when they heat their homes, when they fill up their cars. We're moving toward more natural gas vehicles too, and so that is another great benefit of all this, but we have to have the infrastructure. So I do appreciate the gentleman from Kansas for bringing this bill up. I appreciate the concerns of the gentleman from New York, but clearly a bipartisan majority of our colleagues last Congress said they liked this bill, and I hope we can get this bill moving, and I hope the administration will work with us to move American energy policy forward. I appreciate the time, Mr. Chairman. I yield back.
Gentleman yields back his time. Gentleman, Mr. Collins is recognized.
Thank you, Mr. Chairman. With the gentleman from New York, I just have a question. Do you feel, and maybe this is a philosophical kind, in listening to the testimony and listening to what we've talked about, do you feel it is reasonable or unreasonable for Congress to set any kind of deadlines on approval processes, whether it be FERC or any other deadlines?
Well, there may be an order of reason to that threshold, but I think the most important thing is allowing for the application to be thoroughly vetted so that there is absolute best application of engineer, technician know-how to that process, and making certain that the public is well served in that regard. I have to tell you, wearing a hat as an engineer here and as a legislator, as a Congress rep, I don't think that we should compromise the professional or moral integrity of engineers, technicians, and the like, who are assigned an awesome responsibility that speaks to public safety, public health, the environment, our economy. And, I can very well imagine professionals sitting there at their desks saying, whether they're public or privately employed, by the private sector or public sector employed, I can imagine them sitting there saying, there goes government again, imposing itself on a process of which they know little. And they're telling us how quickly to do something rather than how thoroughly. I want to use my professional skills and apply them for the general welfare. And now government is telling me I can't do that. That compromises their integrity.
Well, I think also, and I appreciate the gentleman's concern, but also there's a flip side to that, that there is also the concern with, even with this, the 9% or whatever you call it, that there is a perception, both real and sometimes perceived, that Congress or government, as you just said, implying its, but there's also this idea that bureaucracy is implying its own interpretation to this process. And if there, again, I think the problem I'm having here is, do we just leave these open-ended forever? I think there's, and there's not just this issue. I mean, you go to Endangered Species Act, there's all kinds of issues that, frankly, left to government discretion, there's no ending sight and date. It's like, we're just going to start this and go. The other thing that concerns me, Mr. Chairman, I looked at the Statement of Administration Policy. I'm a new member of the Rules Committee. I guess this comes with every bill because we've gotten one with every bill that we've taken up. So it's just become part of the process. But I noticed something here that disturbs me, and it does say this. There's basically a veiled or unveiled threat, if you would say, that says, well, if we just don't have enough time, we're just going to deny applications that might otherwise get approved. Now, I'm not sure that's, I'll be generous for a second and say I hope that's not what was intended, But if this is the discussion process here, it cuts against your idea of professionalism. It cuts that these engineers and all are trying to do what they're supposed to be doing without this time limit, that they have this open-ended. It concerns me that administrative policy would actually put this line in this threat of the veto, because basically they're going to say, fine, if you do it, even if we sign this, they'll just not get approved anyway. The American people, sometimes real and sometimes perceived, view government regulation and government red tape, especially many times, as not getting things done when in their own world, they don't have open-ended timeframes. Unless they're a consulting with the government, they don't have open-ended timeframes, and they want to see stuff done. So I appreciate the gentleman from Kansas bringing this bill. I think it's good policy. It's good bipartisan policy. I think we can look forward to. And just as a note, also following up on my friend from Georgia, is having both my committee chairmen here, and they vigorously protect their jurisdiction, so I do appreciate that. And with that, Mr. Chairman.
Will the gentleman yield? Will the gentleman yield?
Gentlemen, yeah.
Thinking about what Mr. Tonko said, if we could work on another bill together where we took all the political people out and all the lawyers out and left it all to the engineers, I don't think we would have needed Mr. Pompeo's bill here today. I don't think it's the engineers that we're trying to rush in this process. I would guess it's folks with the JD as opposed to the
I would say, Representative Woodall, you're going to have a trickle-down theory here that says, okay, we've got this much time, get it done, and I think it's going to affect everybody's input, including the professional input that is so essential here.
And reclaiming my time on this, I think, again, we can continue the back and forth here. I think this is the issue that is, again, what is that proper amount of time? Is there a certain amount of time that in saying yes or no, and there are certain, and I'm not going to rehash the whole thing of complex and non-complex, but to imply that Congress basically stating within a certain proposal and a very, what I would say meager proposal or modest proposal on getting these things done is to impugn the integrity of engineers and consultants and all working these processes. I just am not sure I would go as far as you do. And with that, Mr. Chairman, I yield back.
Gentleman yields back his time. I want to thank both of you for taking time with our committee today. This is a jobs bill, Mr. Pompeo, and it's a jobs bill for the people who would be engaged in building, be a jobs bill for the people who house and give food and have transportation and equipment, and all sorts of people would benefit from this. But I think that your point today about the consumer benefiting with clean natural gas is a good point, and so I want to thank you both for taking time to be with us today. You're now excused.
Thank you, Mr. Chair. It's
Now
our
close
pleasure.
the hearing portion of H.R.
We
161.
know the consumers affected from both ends. So.
And there are consumers that are affected, and I appreciate that. This now closes the hearing portion of H.R. 161, the Natural Gas Pipeline Permitting Reform Act. And I want to thank both the gentlemen. I now will open the hearing on H.R. 36, and we would welcome the gentleman, the dapper gentleman from Virginia who is here, and the equally dapper gentleman from Tennessee. Well, they do look dapper today, both of you. And y'all must have been in Dallas, Texas. I got some sun this weekend because it was a gorgeous day. Mr. Goodlatte, Mr. Chairman, I know you understand you're here at this committee for a reason. Mr. Cohen, you also. We're also hopefully trying to get through, as you know, for the President of the United States, who will be our visitor this afternoon. And we provide our chairs appropriately to our visitors, so we're going to keep moving on this process without objection. Anything you have in writing will be into the record, and the gentleman from Virginia is recognized.
Well, thank you, Mr. Chairman. Since the Supreme Court's decision in Roe versus Wade, medical knowledge regarding the development of unborn babies and their capacities at various stages of growth has advanced dramatically. 35 years ago, after Roe, in the age of ultrasound, or 35 years after Roe, in the age of ultrasound pictures, the New York Times reported on the latest advanced research on the pain experienced by unborn children, focusing on the research of Dr. Suni Anand, an Oxford-trained neonatal pediatrician who held an appointment at Harvard Medical School. As Dr. Anand has testified regarding abortions, if the fetus is beyond 20 weeks of gestation, I would assume that there will be pain caused to the fetus, and I believe it will be severe and excruciating pain. Congress has the power and the responsibility to acknowledge these developments in our understanding of the ability of unborn children to feel pain by prohibiting abortions after 20 weeks of pregnancy, post-fertilization, the point at which scientific evidence shows the unborn can experience great suffering. H.R. 36 would do just that. It also includes provisions to protect the life of the mother and an additional exception for cases of rape and incest. Some members of last Congress and today have called this bill extreme, but such claims are clearly false, as evidenced by the polls, which show astounding support for this bill. A Quinnipiac poll found that 62% of people surveyed support a ban on abortions after 20 weeks or earlier. A clear majority of men, women, whites, blacks, Hispanics, married people, and single people support a ban on abortion after 20 weeks or earlier. Among women, 68% of women support a ban on abortion at 20 weeks or earlier, including 66% of single women and 71% of married women. Even 49% of the Democrats polled supported a ban on abortion at 20 weeks or earlier, significantly more than those who opposed it. A Washington Post poll similarly found 66% support for this bill, and a Huffington Post poll found support at 59%. Today, America is one of the few countries on earth, including North Korea and China, that allows permissive late-term abortions. These polls show the American people want to change that. In the 2007 case of Gonzalez versus Carhart, the Supreme Court made clear that, and I quote, "The government may use its voice and its regulatory authority to show its profound respect for the life within the woman, and that Congress may show such respect for the unborn through, quote, specific regulation because it implicates additional ethical and moral concerns that justify a special prohibition." As we see from the polls, a majority of just about all demographic groups surveyed show the same profound respect for the life within the woman that this bill would protect. Finally, I would note that it is rare for the nonpartisan Congressional Budget Office to be so confident that a bill would save lives that it makes an estimate as to the number of lives that would be saved were the bill to be enacted. But last Congress, the CBO did just that, conservatively estimating that this bill, if enacted, would save 2,750 lives each year. It could save many thousands more. Let that sink in for a moment. This bill, if enacted, would probably save at a minimum almost 3,000 lives per year. It would give America the gift of thousands more children and consequently thousands more mothers and thousands more fathers with all the wondrous human gifts they will bring to the world in so many amazing forms, including their own children for generations to come. I congratulate Subcommittee of the Constitution and Civil Justice Chairman Trent Franks and Marsha Blackburn of Tennessee for introducing this vital legislation. I urge each of my colleagues to support it, and I urge the committee to report out a rule that is appropriate and fair to this process. Thank you, Mr. Chairman.
Thank you, Mr. Chair and members of the committee. This Thursday will mark the 42nd anniversary of Roe v. Wade, a watershed moment in the protection of the fundamental rights not only of a woman to choose whether or not to terminate a pregnancy, but for all Americans to be free of unwarranted governmental interference in their most personal life decisions. H.R. 36 is a direct attack on those rights. It is patently unconstitutional, shows utter contempt for women's lives and health, and demonstrates a near total disregard for the reality that rape and incest victims face. H.R. 36 is so clearly flawed that it's obvious it is merely a messaging bill designed to appear to my friend on the other side's base. The fact that the majority chose not to go through the committee process and to bring this directly to the floor is further evidence of the political nature of this bill. Thursday is the 50th anniversary of Roe v. Wade. That's when this bill is scheduled for the floor. So we see the anniversary of that decision is more important than regular order. And regular order should always be the call of the new American Congress. I don't know if this bill will pass or not. There are some Republicans who have said that this is fundamentally wrong, this bill, and some have questioned the politics of it as far as the Republican position vis-a-vis women. But if it should pass the House and should pass the Senate, surely the President will not sign it. In fact, he'll veto it, and everyone knows that veto will be sustained. H.R. 36 bans all abortions beginning at 20 weeks from fertilization, subject to a fine of up to 5 years or a fine of up to 5 years in prison. A fine or up to 5 years in prison, or both, for the person who performs that procedure. The bill has only two exceedingly narrow exceptions, one for cases when a physical condition threatens the pregnant woman's life, and one for cases of rape or incest against a minor This incest is against a minor only if such rape or incest has been reported to the authorities. H.R. 36 represents a direct challenge to Roe and a woman's constitutional right to choose whether or not to carry a pregnancy. Roe has been the law in the United States since 1973. And the line of decisions following it have all made it clear that prior to the point of a fetus's viability, a pregnant woman has a constitutional right to determine when and if they choose to bring life into this world. That's not based on polls. That's based on law. It is generally acknowledged that viability does not begin until 22 to 24 weeks after fertilization, as the New York Times noted today in an editorial. That's the issue, viability, not pain. And the physician that was cited by my colleague and friend is a minority opinion voiced by one physician, and there are many more physicians who would question that. And even he assumes that the fetus would feel pain. Therefore, by banning pre-viability abortions, this bill will impermissibly narrow the window within a woman may exercise her constitutional right to terminate a pregnancy. In short, if H.R. 36 is upheld as constitutional, it would be by implication, it would overrule Roe. That is why the U.S. Court of Appeals for the Ninth Circuit struck down an Arizona law that was quite similar to H.R. 36. As the Court noted, the Supreme Court's decisions have been unalterably clear regarding one basic point. A woman has a constitutional right to choose to terminate a pregnancy before the fetus is viable. A prohibition on the exercise of that right is per se unconstitutional. Another disturbing feature of H.R. 36 that endangers women's health by containing no health exception and only a limited life exception. The bill currently contains an exception only for cases where the pregnant woman's life is endangered by physical disorder, injury, or illness. The exception specifically does not include life-threatening psychological or emotional conditions, including suicidal thoughts, and does not even cover severe threats to the woman's health. In both Roe and Doe v. Bolton, a companion case, the Supreme Court made clear that a state cannot prohibit an abortion under any circumstances where the woman's life or health, physical, psychological, or emotional, is at risk, and that this determination must be left to the woman. She may consult with her family, her doctor, her faith, but it's the woman's final decision. In addition to further calling into question H.R. 36 constitutionality, the lack of a health exception potentially places women's health at grave risk. Most abortions performed after 20 weeks are done so for medical reasons, including cases where no medical treatment can save the fetus. Oftentimes, such conditions are not able to be confirmed until after the 20th week. H.R. 36 would force a woman to carry a fetus, even when doing so would cause serious, long-lasting health problems for her. Complications from pregnancy include various heart disorders, kidney disease, pulmonary hypertension, and certain cancers. The limited nature of the life exception and the lack of health exception are both morally and constitutionally wrong. H.R. 36's very narrow exception for rape or incest demonstrates a disregard for the reality of the situation women are put in when they suffer from rape or incest, and the lack of a desire for them to come forward and make it public. And it shows a lack of respect for the victim's honesty and trust that the victim would come forth and be honest in their dealings with their physician. According to a study by the American Journal of Obstetrics and Gynecology, more than 32,000 pregnancies result from rape each year, and rape-related pregnancy occurs with significant frequency. The rape exception in this bill is only available if it was first reported to law enforcement. The reality is many instances of rape go unreported because of the emotional and psychological toll that victims suffer in reporting a rape. That is why even the Hyde Amendment, whose original author was a staunch abortion opponent, contains a straightforward exception for rape or incest with absolutely no limiting language. H.R. 36's narrow rape exception will fail to help many victims who will again be violated or victimized by being forced to carry a rape-related pregnancy. This bill is deeply flawed, harmful, insulting to women, and it's why the administration strongly opposed an identical bill from the last Congress, noting that the bill showed, quote, contempt for women's health and rights, the role doctors play in their patients' health care decisions, in the Constitution. I don't know if the polls that were cited by my friend and chairman are accurate or not, but polls aren't what should be driving this Congress. It's important we listen to our constituents, but before the horrific slaughter of the folks who protested in Selma, Alabama about voting rights, polls would have said the majority of Americans, indeed the majority of Americans living in the districts and states that were affected by the Voting Rights Act, were against passing the voting rights law. There are lots of situations where polls have not been in keeping with what the American Congress should be doing and what is morally and right and appropriate. Polls show today that close to 2/3, if not 3/4 of Americans want medical marijuana. But we don't see the majority coming forth with bills that the polls say the American people want. I strongly oppose this bill and say we shouldn't be legislating by poll, but legislating by what's right for women and what is the law in this land, and not to be passing bills that we know will be vetoed and are messaging bills, but instead we should be dealing with the issues that are important to the American public, which are jobs bills that create jobs and infrastructure and put people to work and take goods to market and keep America strong as one of the leaders in the world on infrastructure, which we're not any longer, on the minimum wage and other opportunities for the middle class to achieve the American dream through education and through tax reform that's directed at the middle class. Thank you, Mr. Chairman.
Thank you, gentlemen. Thank both of you very much.
Thank you, Mr. Chairman. Before I make my comments, with the committee's indulgence, I'd like to welcome to the committee 3 friends of mine who are in town, Mrs. Sandra Henson, Ms. Laura McGee, and Mr. Teddy Kreider. They drove up from Chapel Hill today, Chapel Hill, North Carolina, and Mrs. Henson will be my guest tonight for the State of the Union address, and I'm delighted that they're here. I know, Mr. Chairman, we're under some time constraints, and so I'm going to be brief, and I hope my colleagues will extend the same courtesy. I do want to thank the chairman for his wonderful comments, and I would like to get a copy of those comments to use when I write to my constituents about this issue, Mr. Chairman, because I think your comments are right on in every way. And I have a lot of respect for my colleague, Mr. Cohen. We're classmates here. But I do have to say, this is a vitally important bill, and I think it's fitting that we're going to consider the bill tomorrow on the anniversary of the tragic Roe v. Wade decision that gave American people abortion on demand. But I have to say, Mr. Cohen, and again, you and I know each other well and like each other, polls are not what drive Republicans to action. This is not a messaging bill. I'm sorry that you feel that way. We have a very strong sense of morality, and that's what's driving this legislation, as it has driven it in the past. As you're well aware, when it passed before, it didn't pass in connection with any pro-life or anti-life anniversary. I have great concern about the comment you made, too, about this bill showing an utter contempt for women. I take a very different point of view. More than half of the babies who are aborted are females. And I always want to remind people of that, because killing those unborn babies shows utter contempt for life. And that troubles me. There are many points of view on abortion, but I do believe the chairman's comments that there is substantial agreement by a wide variety of the American people, over 60%, that unborn children who've developed for 20 weeks in the womb and are capable of feeling great pain should be protected. That consensus is a terrific development. Mrs. Henson brought me a copy of the Raleigh News and Observer, not known for being a real liberal newspaper, a conservative newspaper, excuse me, about a youth event that occurred in downtown Raleigh in conjunction with the Right to Life celebrations we're having. And it talks about how the numbers of young people have increased in participating in this. And those of us who go to the March for Life here in Washington have seen that. And so I think we are winning the pro-life battle in this country, and I'm very encouraged. I hope the Senate will pass the bill, the President will sign it, so we are not the country that mirrors on-demand abortion that only 6 other countries, including North Korea and China, share with us. That's not a reputation that I think we should have. And while the bill this session has not gone through regular order, it did go through regular order in the past, as are the other bills. So I thank the chairman. I apologize for taking up so much time, but I do think it's important that we reiterate that this is not driven at all by messaging or by an anniversary, but our strong sense of morality and our strong willingness and desire to protect life. Thank you, Mr. Chairman.
I did not mention earlier, but my 21-year-old Down syndrome son, Alex, celebrated his birthday yesterday. And Alex is, for those of you that know Alex is one of the coolest guys. He's an Eagle Scout. He wants to live independently. If you ask him what the word is, he'll say the word is can. He has a great attitude. And he has provided immeasurable things to not only those that meet him, but those that have heard of him. And it's an example of what Virginia talked about when she talked about the life of our children. I thank the gentlewoman. The gentlewoman from New York is recognized.
Thank you, Mr. Chairman. I don't really appreciate having my morality questioned here. There are 2 lives involved here. Some concern, obviously, is shown for a woman. I've gone through this for so many years. We've voted this thing 3 times. And if you tell me it's not against women, I'm not going to ever believe a word of that. You're saying to women, you can't make that decision. And you're even saying to scientists. Now, look, I understand these last couple terms here that to most of the majority in this House, that scientific facts are only suggestions. But scientifically, everybody says that it's absolutely impossible at 20 weeks for a fetus to feel pain. Now, you may know better than that, perhaps. At least I know you're pretending that you do. But there's a word for it that I just heard this week that I think kind of sums it up. Calling people a gynetician. Have you heard that? A gynetician is a politician who believes that they know more about women's health than doctors do. Maybe you could put that on your resume. But I think this is sad. I want to give the statement of the administration's policy. This is totally unconstitutional. I think what Mr. Cohen said was perfectly apt. The fact that women have to go to report to the police to be able to get any kind of help, isn't that the same as women don't get pregnant from rape, or that women have some ability to shut that whole thing down? Haven't we heard enough of that? But at any rate, this administration strongly opposes H.R. 36, which would unacceptably restrict women's health and reproductive rights and is an assault on a woman's right to choose. Women should be able to make their own choices about their bodies and their health care, and government should not inject itself into decisions best made between a woman and her doctor. Over the past 40 years, since Roe v. Wade, the Supreme Court has affirmed a woman's constitutional right to privacy, including the right to choose. H.R. 36 is a direct challenge to the Supreme Court's holdings on abortion. Not only is the basis for H.R. 36 scientifically disputed, the bill disregards the woman's health and rights. The woman is totally disregarded. She's simply a vessel to many people in this Congress, that she has no right to speak or to say about anything, or what her life would be, or whether her life would even exist. Furthermore, the provisions require rape and incest survivors to report the crime to a law enforcement agency when 88% of women don't do it, and that, again, should be a right that they have to choose. But anyway, to do that with the 20-week mark demonstrates a complete disregard for women who experience sexual assault and the barriers they may face in reporting. And you make the decision here in Congress that nothing would happen after 20 weeks that could cause some health problems. There's nothing they could do about it under this law. Research indicates the majority of survivors have not reported sexual assaults to law enforcement. Now, the administration is continuing its efforts to reduce unintended pregnancies, which is what we all should be working on, to expand access to contraception, to support maternal and child health. You know, Barney Frank, who was congressman here, made the most cogent statement about this kind of argument, that everybody really believes that the fetus is their responsibility till it's born, and then you have no more responsibility for it. Congress doesn't have to worry if they're fed or clothed or housed or educated, just that they're born. The administration is continuing its efforts to reduce unintended pregnancies, to expand access to contraception, support maternal and child health, and minimize the need for abortion. At the same time, but there are cases where it is needed. At the same time, the administration is committed to the protection of women's health and their reproductive freedom, to supporting women and families in the choices that they make. The president would be advised to veto. When we went through the late-term abortion problems, I met so many women who desperately wanted that child they were carrying. Some cases, they had no brains, could not possibly survive, could not even take a breath. And yet people were insisting that they not do anything about it. Fetuses can die in vitro, causing blood poisoning, other conditions for the vector, the carrier, that needs some attention. Why isn't some attention being paid to that? With all the things that we have to be doing, with all the problems that we have in the United States, with all the concerns that we have, and I don't believe that poll, and if you want to think about that, I understand that a poll somewhere, sometime, I don't know the truth, but a fairly substantial number of Americans believed that Joan of Arc was Noah's wife. I yield back.
The woman yields back her time. The gentleman from Oklahoma, Chairman Cole's recognized.
Thank you, Mr. Chairman. I won't take a lot of time. I want to begin by associating myself with the remarks of my friend from North Carolina. I thought stated the issue very eloquently and very appropriately. I do want to make a quick comment. I appreciate first my friend Mr. Goodlatte carrying this legislation. I know it's something in which he deeply believes, and sometimes we do have issues that just simply do divide us. People of goodwill and strong belief can be on different sides. My friend, Mr. Cohen, somebody that I respect greatly in this body, he's always thoughtful, but this is just one where I find, as a rule, most people have made up their mind long before they arrive here. And it's usually done out of profound personal conviction. It's not done any other way or to score political points or anything of that nature. I've just never seen people that care passionately on either side of this issue motivated by that. They care about the issue. I do want to offer one reflection. My friend from Tennessee may want to respond. He did point out the president had threatened to veto this if it reached his desk. We see a lot of those up here. That's not an unusual document for us to see. But I do think it's a mistake, particularly on an issue like this, to allow any side to effectively limit the debate by saying, well, so-and-so here won't accept it. We're going to hear a lot of proposals tonight that the president's going to lay in front of us that I can assure you aren't going to be accepted. And he's not going to pull back from what he believes the right thing to say or do is because they're not going to get a favorable reception legislatively here. I don't think there's anything wrong with that. I think that's one of his functions as President of the United States. I think on this kind of issue, where I agree with my friend, Mr. Fox, I used to poll for a living. This has been an unusual issue in the sense that the country has actually become somewhat more conservative on this issue. I think partly because of sonograms, partly because of seeing the unborn. And I'm not saying opinion's not settled or my friends are settled, and my friends make, but I can tell you, opinion has drifted this way. And part of it, too, are the very discussions that we have in the course of a debate like this. And on both sides, I think, again, it's an issue that is this polarizing, tells you that people just feel very strongly about it. But I think, again, appropriate thing is to allow the debate to proceed, to allow people to express their opinions, and we'll just see how the constitutional process works out. So if my friend has a comment to make, I'd certainly yield him time.
Thank you, Mr. Cole. I appreciate that. First, I'd like to say to my friend, Ms. Fox, and just for the historical record, I think you got here 2 years before I did. I wish I'd have gotten here in 2 years, about a year. I think you're 2 years ahead of me. The issue of morality, I think both sides think that they're on the right side of morality, and I don't think any side has a monopoly on that. I'm a strong believer that the government should stay out of individuals' bedrooms and out of their personal lives, and whether that deals with sexual relations or pregnancies or other areas such as that, I think the government should stay out. Generally, Republicans think the government should stay out of people's lives too, but there's part of the home where they think it's all right, generally, and I don't think it should be. The chairman is a wonderful father, and I know your story and what's happened, and I commend you for that. But I've always felt that it's a woman's right to make that decision. I was in law school when Roe v. Wade came out. I felt it was a great decision and a great opportunity of extending freedom to women and to people in this country for making that choice. And if you limit and overrule Roe v. Wade, what's just simply going to happen is people are going to go to back alleys and illegal abortionists. In Texas, where they're making it much more difficult, and in Tennessee, where an amendment passed with 53% of the vote, and I'm sure the General Assembly is going to have a field day in trying to put more restrictions on abortion, it's just going to mean that people are going to go to non-qualified back alley places to get abortions, or those who can afford it will travel to states where it's legal, and those who can't won't. It makes it to where it's somewhat your income and ability to afford an abortion and not, and it's not really right, and what I think it should be a fundamental right of a woman to make that decision. As far as Mr. Cole saying, and I understand what you're saying, because the President's veto, it doesn't mean maybe the House here shouldn't pass it. But on that same line of logic, I think that says that this committee should allow there to be amendments to be voted on by the floor and to see if the amendments pass or fail. So I presume with that logic, which I can concur in, there should be an open rule and allow the House to vote on exceptions for the health of the woman, for rape and incest without having to report it to police, and let the House determine what legislation should pass.
Reclaiming my time, I think the House will determine what's going to happen here. The Rules Committee will make a determination, and we'll make a determination on the floor. And whatever's decided on the floor, any point of view can certainly be appropriately expressed, including about what some people would regard as defects in the legislation. So I don't think there's going to be any effort to limit debate. Yield time to my friend from Virginia.
I thank the gentleman for yielding, and I want to thank him for his comments and confirm my view also that I have great respect for the opinions of others, and I have great respect for the right of women, absolutely. But there are two rights involved here. There's a right of a mother, and there's a right of an unborn child, particularly a child that is more than 20 weeks of age, late term, capable of feeling pain, and is entitled to protection under the laws of the United States, just like that mother, and that's what we're about, the business here today.
Again, reclaiming my time, I think my friend states it very eloquently. It's one of these difficult issues where there are competing rights and interests, and people look at them in different ways. I do think science has told us, we've learned a great deal in the last couple of decades about this that we probably weren't aware of. I think changing public opinion recognizes that. And I suspect this will be a discussion that we have for a long time to come. But having said that, I'm still in the corner with my friend from Virginia and my friend from North Carolina. It's an issue I feel strongly about. It's an issue I know my friends of a different view feel strongly about, and I respect that. But again, that's why we have legislative chambers to work this out, and I think the appropriate thing is to hold the vote. It's not an issue that we need to learn, that most of, I shouldn't say we need to learn, we always need to learn more, but I do think it's an issue where most members have a fairly settled point of view. So I think we'll find out what that is. With that, I yield back, Mr. Chairman.
Gentleman yields back his time. Gentleman, Mr. McGovern.
Thank you, Mr. Chairman. And again, I mean, if we're going to argue that the President's veto threat is effectively going to limit debate, it's hard to make that case and not allow for an open process on the House floor. There's, you know, if we go the way that I predict we're going to go, this will be a closed rule. So people won't have, that will limit people's ability to effectively have any input on this debate. We can express our opinion, but we can't do anything about proposing alternatives. And my problem, one of my biggest problems, I mean, I agree with the ranking member said, but, you know, I mean, the problem with these kinds of bills is that, you know, it doesn't take into the fact that life can oftentimes be complicated. I mean, the older I get, the more complicated I realize life is. Things always don't fit into nice, neat categories. Life is less black and white, more gray. And so, you know, this is, to me, I'm glad the President has put out a veto threat, because I think this is a bad piece of legislation. I guess I'm curious about one thing here. Why have you placed conditions on the exemptions for rape and incest included in this bill? I mean, do you actually think that women would lie to their doctor about rape and incest to get an abortion? And why is the incest exemption of this bill, why does it apply only to minors? Does the chairman think that only minors can be victims of incest?
First of all, the fact of the matter is that this is identical to the bill that was passed by the Congress in the last session. Secondly, we're talking about late-term abortions. We're talking about abortions that the woman has been carrying the child for more than 20 weeks. So it seems to me that it's entirely appropriate, if we're going to have an exception for rape and incest, and we do have one in this bill, that there be some protections that the child indeed be being aborted because they are the product of a rape or an incest.
But the incest exemption only applies to minors.
Correct.
So, I mean, could an adult, you know, someone who's not considered a minor be a victim of incest as well? And isn't that horrendous as well? I mean, I think as Mrs. Slaughter pointed out, you know, we do know for a fact that rapes and incest is not always reported to law enforcement for a whole variety of reasons. It's a very tragic, horrific, you know, ordeal for anyone. And the idea, I'm just trying to understand why, you know, why we have these, you know, why we're limiting the exemptions with regard to rape, and why the incest exemption only applies to minors. I'm just trying to figure out.
Sure. Well, I think it's pretty plain, I think, that if you're carrying a child for more than 20 weeks and you have been the victim of a rape, that's certainly recognized in law that you'd be entitled to an abortion under those circumstances.
But you'd have to go to a law enforcement official to report
only
it.
the day before, for example, that you got the abortion. It wouldn't be months or weeks before that. It's a simple requirement that it be done before the abortion is provided, and it's an assurance to everyone involved, including the public and others interested in the welfare of the child, that the abortion provider is not simply checking a box and going ahead and doing that, might do that without the mother even knowing that
Yeah, maybe it's plain to you. It's not plain to me. I don't know. Mr. Cohen, do you have anything to add to?
I just think that what these are rape and incest light, and women's rights should never be taken lightly. And Mr. McGovern, you're exactly right, and I think my friend, the chairman, couldn't give you an answer because there isn't an answer on why somebody should only be limited incest to a minor. If the person's 18 and they had sex with their 19-year-old brother or their 40-year-old father, that should have the same exception and not have to be reported.
Well, if the gentleman would yield further, I strongly disagree with that. I mean, a minor is a minor and not always able to make their own decisions and understand what they're doing. But that language was added to be clear that consenting adults in an incestuous relationship do not get a free pass to have a painful late-term abortion up to the point of delivery. So,
I mean, all right, Mr. Cohen?
Thank you. Consenting adults is an issue.
Right.
And are they consenting when the father might have control over the daughter to have sex? It may not be consenting. And
If the
it may
gentleman
be,
would
there may
yield.
be, and the other thing is, you know, I don't know if the bill makes it clear whether if the child is a minor at the time of conception or a time that they choose the abortion, but they could be a matter of days, like 17 years, and I know there has to be times in 361 days of life and all that they can have certain rights and otherwise. I would say there shouldn't be any of these exceptions should be done as I say, rape and incest light. They should not be taken lightly. This is a woman's right to choose. Every woman should make this decision and not the government. This is a situation where we're putting the government over an individual.
Yeah, I mean, I'm troubled by the bill in general, these provisions are even more troubling. And and again, I regret that we're bringing this to the floor, but if we're going to do this, bring it to the floor, then I think we ought to have some regular order. If we're not going to go through committee, gentlemen.
I would also take exception to what Ms. Fox said about abortion on demand. We don't have abortion on demand in this country. You can't go in after certain periods and get an abortion. There is no such thing as abortion on demand. And while we may be, and I don't know the facts about China and Iran and North Korea, without getting into another difficult subject to debate about the death penalty, we're in the same class with China and North Korea and Iran on on the death penalty. And yet we don't, because of that, run away from that. And the polls may say something else. When I mentioned polls, I didn't mean to question anybody's morality. But my friend, the chairman, brought the polls up in support of the proposition, which was why I brought up the polls. And it's not a coincidence that this is being brought up on the day of Roe v. Wade. It makes good drama. It makes good theater. It makes good politics. Women's rights should not be theater, drama, and politics.
Mr. Chairman, I yield back the balance.
Gentleman yields back his time. Thank you very much. The gentleman, does anyone seek time? Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate you bringing this bill. I voted against you last year. I happen to agree with Mr. McGovern's concerns, and Mr. Cohen's concerns. Either we believe in life or we don't believe in life. And when the federal government gets in the business of trying to substitute its morality for our morality back home, number one, I think the good people, the men and women of Georgia, lose in that debate, because we will always have a better and keener compass for morality than will Washington, D.C. But we find ourselves having the conversation that you and Mr. McGovern just had. At 19 weeks and 5 days, life is not significant. But at 19 weeks and 7 days, suddenly the federal government will protect that life. And I cannot express my contempt for having the Supreme Court put us in that situation. I recognize what Mr. Cohen's saying about the impact of economics when states are regulating these areas, and I'm sensitive to that. I don't dispute the merits. What I have concluded is you've done the very best you can with a really lousy hand that you've been dealt. We went down this road in 2003, and folks said, you know what, the Supreme Court's going to say no to the partial birth abortion ban. They've already ruled 5-4 against Nebraska on a very similar rule. There's absolutely no possibility that this can be upheld. And we went to lower courts, and we went to appellate courts, and time after time after time, those courts said absolutely not, there can't be a partial birth abortion ban in America, until we got to the Supreme Court, when the Supreme Court said we do have a vested interest in protecting life. I don't think this is the right language. I don't think the federal government ought to be in this space. But the Supreme Court in Roe versus Wade forced the federal government into this space. And while your bill is not going to protect all life, your bill is going to make a difference for 2,700 children a year. We talk about doing those things that we can to make a difference. Martin Luther King said, genuine leaders are not searchers of consensus, but molders of consensus. The work that you are doing on this bill is molding consensus around the country, molding that support for life. I've read a lot of presidential veto statements in my time on this committee. This one says very specifically, the president were presented with this legislation, his senior advisors would recommend that he veto a bill. You know, I often see where he says if the president is presented with this legislation, he absolutely will veto a bill. And I see senior advisor language put in there when he wants a little space in there. I think America's coming together on molding that consensus of the value of life in this country. Last year, when we didn't have a Senate that was moving legislation, you could have argued that this was a messaging bill. This year, when we have a Senate that is committed, as you are committed, to moving legislation. This is no longer a messaging proposition. This is a question about the 2,750 lives that you and the CBO.
With the gentleman yield.
Be happy to yield.
I appreciate the gentleman's comments, and I would join him in the desire to save a lot more unborn children than we are able to do in this. And quite frankly, if the Supreme Court in 1973 had the knowledge that we have today, had the scientific information that we had today, had the moral support of the public, and you can measure that in a lot of different ways. You can criticize some of the ways you measure it, but it's very clear, as has been noted here today, that the public has become much more aware of this and much more strongly supportive. But had this law been taken into consideration in that decision, as bad as that decision is, as wrong as that decision is, if it had been modified just by this much, we'd have saved over the, not 50 years, but 42 years since Roe versus Wade was passed down. We'd have saved an additional 120,000 lives by this measure. I don't think we can wait any longer to start down that path.
Mr. Chairman, you can't have these kinds of conversations without men and women of integrity leading that debate on both sides. I appreciate Mr. Cohen and Chairman Goodlatte for being here today. I yield back.
Chairman yields back his time. Thank you very much. The gentleman from Colorado is recognized.
Well, I think it's unfortunate that we are discussing an issue that is between a woman and her doctor and her God here in Washington, and sitting around and talking about or forcing Washington decisions on whether two people engaged in incest are 50 and 19 or 50 and 17. I think it's not an appropriate discussion for us to have. And when a woman faces what is often one of the most difficult decisions of her life, I hope that she gets all the information and including about alternatives, and consults with her doctor and, of course, with any faith leaders that are important to her, and makes the appropriate decision. It's not really for us to make here in Washington. I yield back the balance of my time.
Gentleman yields back his time. The gentleman, does anyone seek recognition? Gentleman from Northwest Georgia is recognized.
Thank you, Mr. Chairman. I think what was interesting, and I appreciate both Mr. Cohen and Chairman for both I work with on Judiciary Committee. I think one of the things that my friend from Massachusetts said is true. Life is not black and white. And over the past 25 years, it has become in color and in 3D. Science has changed. I appreciate my friend from Georgia and also from Colorado on the statement just made. I do believe, however, this was forced upon us from Washington by a court that said this is the way it will be. You see, as I have talked about this before, is science has changed. Because when my daughter was first born, there was no in vitro surgery that could have closed her back, that possibly gave her a chance to walk. Because at that time, they didn't have that. She can now, after having 30 surgeries, could have surgery, instead of shaving her whole head, shave just a little bit to change the shunt in her head. You see, science has changed. And life in this bill, and I appreciate the chairman sitting here and bringing this bill in the debate that has ensued, because it brings to truth what I believe is very important. As unlike my wife was told almost 22 years ago this week, if your baby has a problem, you can do away with it. That baby's 22. And it's a child. And although I would love to see different language here, and I agree with the chairman and my friend from Georgia, when you look at this, what this bill does do, and even for those in my state and from others who have contacted me saying this doesn't do enough, I agree, but I will say this. We're having a discussion today about what matters. And I believe this bill, although it could have other things that I would like, it takes a positive step forward in discussing the goal that I believe is important here in Congress, and that is all life matters, from conception to natural death. And that is what we're standing for, and that is what matters. Mr. Chairman, I yield back.
Gentleman yields back his time. I want to thank both of you for being here. I believe that your conduct on both sides and your testimony was appreciated and respected today. Mr. Cohen, thank you very much. Mr. Chairman, once again, very good to see you, and thank you very much.
Thank you, Mr. Chairman.
And Mr. Chairman, I want to thank you
Yes, sir.
for your notice of my dress. I thought about it when I woke up this morning and appreciate the compliment.
Well, you equaled what I said. Thank you very much.
Hey, Steve, I still claim you're a classmate. I'm sorry.
I was 06.
You know, Steve, I would have just said yes, ma'am, if I were you, but I'll let you, that's between you and whoever. Thank you very much. This closes the hearing portion of H.R. 36. Close the hearing portion now, and we'll move to a motion from the gentlewoman, Vice Chairman of the committee, the gentlewoman from North Carolina.
Thank you, Mr. Chairman. I move the committee grant H.R. 161, the Natural Gas Pipeline Permitting Reform Act, a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides one motion to recommit. Section 2 of the rule provides for consideration of H.R. 36, the Pain-Capable Unborn Child Protection Act, under a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary or their respective designees. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. Finally, the rule provides one motion to recommit.
You've now heard the motion from the gentlewoman from Grandfather Community, North Carolina. Is there amendment or discussion?
Yes, Mr. Chairman, I have an
Gentlewoman
amendment.
from New York is recognized.
I move the committee grant H.R. 161 and H.R. 36 each an open rule so that all members have the opportunity to offer amendments to the bills on the floor.
You now heard the motion from the gentlewoman, the amendment from the gentlewoman from New York. Further discussion? Gentleman's recognized.
Yeah, just, I want to support the gentlewoman's amendment. Everybody here says that these bills, require important discussions. It would be nice if those discussions weren't just one-sided. And given the fact that these bills aren't going through regular order, I would urge my colleagues on the Republican side to open this process up so people, including a lot of the new members, have an opportunity to be able to offer their ideas and debate them on the House floor.
Further discussion? Vote now be on the amendment from the gentlewoman from New York. Those in favor signify by saying aye. Those opposed, no. Those have it. Gentlewoman asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? Mr. Woodall? Mr. Woodall? No. Mr. Burgess? Mr. Stivers? Mr. Stivers? No. Mr. Collins? Mr. Collins? No. Ms. Slaughter? Yes. Ms. Slaughter, aye. Mr. McGovern? Mr. McGovern, aye. Mr. Hastings? Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman? No. Mr. Chairman, no.
Clerk will report the total.
3 yeas, 5 nays.
The amendment's not agreed to. For amendment or discussion, gentleman from Massachusetts recognized.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 161 by Representative Tsongas, number 1, which would exempt pipelines from the timelines established in the underlying legislation if the pipeline passes through lands managed for purposes of natural resource conservation or recreation. And as I mentioned earlier, Mr. Chairman, that this amendment keeps the existing review process in place for proposed pipelines that cross federal, state, or local conservation or recreation lands. But the point is, if we've already invested federal and state money into identifying these lands as environmentally sensitive, it makes no sense to expedite the approval of a pipeline that could bulldoze right through them. This amendment doesn't say that a pipeline can't be approved. It simply says that we should allow for a thoughtful and thorough review process that shouldn't be rushed to meet an arbitrary time deadline.
You've now heard the amendment from the gentleman from Massachusetts. Further discussion? Seeing none, the vote will now be on the amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
I ask for a roll call.
Noes have it, roll call.
Ms. Fox?
No.
Ms. Fox, no. Mr. Cole? Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 5 nays.
The amendment's not agreed to. Further amendment or discussion? Seeing none, vote will now be on the motion offered by the gentlewoman from Grandfather Community, North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, ayes have it. Roll call is requested.
Ms. Fox? Aye. Ms. Fox, aye. Mr. Cole, Mr. Woodall? Mr. Woodall, aye. Mr. Burgess, Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Aye. Mr. Collins, aye. Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings? Mr. Polis? No. Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report total.
5 yeas, 3 nays.
Motion is agreed to, motion is agreed to, and thank you very much. I want to thank Ms. Henson for being here. Sandra, good luck tonight. I know you got a great partner who will be having dinner with you and enjoying yourself, but we want to thank you for taking time. Laura and Teddy, I hope you guys also equally have a good time. We're delighted that you joined us in the Rules Committee. You'll get a chance to see Mrs. Fox, who will be handling this on the floor tomorrow, your favorite member of Congress. And so you'll get a chance to watch our star. And the Democrats will have a gentleman
Your
from,
second favorite member of Congress.
from who overall, that's right, the poster boy for fun. The gentleman is a lot of fun, and you'll get a chance to see firsthand what we do, the life and times of not just this, but also good theater. So I want to thank both of you very much.
Mr. Chairman.
Gentlewoman's
Mrs. Henson
recognized.
brought a
Something for
lovely
me?
box of candy, which
Oh,
I'm gonna
for us.
put in for the staff,
Oh, the
both the
staff.
Democrat and the Republican staff.
I got a question.
So-
Is there chocolate in there?
There's chocolate in there.
All right, Sandra, just so you know, I love chocolate. Thank you very much. I do not anticipate or expect at this point that we would have another meeting during the week for the committee. We've done our work for the day, for the week, and thank you very much. By the way, staff, thank you very much. Enjoy the chocolate. This now ends our hearing for the day.
Yes, there's the names.
Excellent, thank you.